So we always do on Wednesdays the jargon of the day. And as you know, this year we've been tackling new jargon that apparently we'd never done before, because I can't even believe that 10 years and there was jargon that we hadn't done, but apparently. So today's jargon term is not a fun one. This is not like, well, yippee, I get to know what this is. If you get to know what this term is, if you already have heard of it, or if something happens, I lost my solidarity drag. There we go. If this term comes up, you're already in the skids, right? But it's important that you know what it is before you get in the skids, because sometimes just knowing what it is can help you to avoid it. Okay, so let's take a look. We give you the actual definition. When possible, we make fun of it. We're not going to do that today because it's too serious. And then we give you a working definition to help you to know what the skinny on the situation is, because sometimes you can understand what the thing is, but when you don't know what the consequences are for not doing something, like, you got to understand the context of these things, right? So let's take a look at what today's jargon term is. Again, new, we've never done it before. Manifest determination hearing. Oh, doesn't that sound like 68 kinds of fun? Guess what? It's not. So let's take a look at what our actual definition for this is. This is, it's a meeting to determine whether a student's misconduct in school has resulted from their disability. This step is required when the disciplinary action involves a request for a suspension or other actions involving removal from a program for more than 10 days. Oh, well, that's some serious business, right? So if your kiddo does something that is severe enough that they start talking about consequences, and among the consequences are, he can't be in this program anymore, she can't be in this school anymore, they can't be in this classroom anymore, or we're suspending them and we want to suspend them for more than 10 days because, IDEA says you can't suspend a student with a disability because we don't punish disability, right? But this is where we get into this moment where they've got to have this meeting, and let's take a look at what our actual definition is so that we understand the context of this. Because what this is serious business. This is serious business where you have to make sure that your child maintains their protections under IDEA. So if they start talking to you about a manifest determination hearing, you have to get your ducks in a row to show why whatever it was that happened was either a result of poor placement or poor management on the part of the school, or that it resulted purely from their disability. Because if there are protections under IDEA, which is the Individuals with Disabilities Education Act, and under IDEA, it says you can't punish someone for having a disability. So if your child, let's go to extremes. Let's say that your child picked up a desk and threw it across the room and hit some with it. Now that's serious business, right? And we can't have that. I think we can all agree on that, right? But did the child do that because of their disability? If they did, then they can only suspend them for less than 10 days. And they can't take their program away from them, right? Because my question is, what happened? What happened before? Why did this child pick up a desk and throw it? Because, and I'm just going to talk in terms of autism right now, but this covers anybody who has any disability. If you have autism, it is not a symptom of autism that you pick up desks and throw them. And you didn't just do it randomly. That doesn't exist. So why did this individual pick up the desk and throw it? Did they pick up the desk and throw it because no one was supervising the class and they were being hit by other students? In that case, that is a mismanagement of the classroom structure, and it is not your child's fault, and they cannot lose their program because of it. Then the school has to change what they are doing and the supports that they're providing. Did the child do it because there was a blinking light, and the blinking light and we have a documented sensory issue and the child cannot handle it when there are blinking lights? Because I couldn't. I don't know that I'd pick up a desk and throw it, but probably eventually I would, because I can't handle that, right? And so if it is documented that this individual cannot be around strobe lights, that they have severe reactions, then you can't remove them from the program. Again, you got to change the strobe light. So the thing that's horrible is that usually a parent doesn't hear this term until it's happening. And when it's happening, it has to happen quickly, like quickly. And you don't have time to get your ducks in a row. So I wanted to bring this up today to make sure that you guys have this term in your back pocket, that you know. And I really would rather talk about how we don't get to a manifest determination hearing. That if there is any behavior that is happening in the classroom that is challenging, that you demand deny, like they send home a note and say, Johnny did this in class today. The first thing that you do is you start an email train and you say, well, what happened? Is anybody taking data on that? Did anybody have eyeballs on the situation? Because my kid just doesn't do things randomly, right? And you would think that the school knows that, but they act like they don't. Some of them, not everybody, right? So you got to, anytime a note comes home about behavior that is not appropriate, you got to be challenging them. What happened? Ask them to do a functional behavior assessment on it. Ask them to put a behavior intervention plan in place and be a part of deciding what the behavior intervention plan is, and have the behavior intervention plan attached to the IEP. There's a box on the first page of the IEP that says behavior intervention attached. And when they check that, that means that the BIP, the behavior intervention plan, is a legal part of that legal document. And if they don't follow it, it's certainly not your child's fault. It's theirs. We have to protect our kids. We have to protect our kids and make sure that IDEA is great. IDEA is great. It's not perfect, but it's great. And it put a lot of protections into place for our kids. But remember, it has never been fully funded. Thank you very much. We've heard a lot of people talk about over the years that they're going to fully fund it. Joe Biden has promised us, and standing next to his wife, Jill, who's an educator, they have promised us that they are going to fully fund IDEA. I understand there's been a pandemic, but I'm still holding Joe accountable. I said you were going to do it. Where is it? I need to see it. It needs to be fully funded. And as parents, we got to fight to make sure that our kids maintain rights. I also want to say one more thing. Manifest determination hearings are hard, and a lot of schools lose them because more parents are getting smart. So they found a way around it, that what they'll do is they'll suspend your kid for 10 days. They'll let them come back for 1 day, suspend them again for 10 days, let them come back for 1 day, suspend them. Don't let that happen to you. Lawyer up, advocate up. Don't let your child be shoved to the side and not be educated. The letter of the law says that your child has a right to a free, appropriate public education. That doesn't mean that they're going to serve it up on a platter. We got to get serious, put our dukes up, and fight. Parker says, I had that hearing when I was a senior in high school. I was kicked out of school and sent to a center in Ohio. Parker, I'm sending you a hug because, I wished I'd been in your school because you're amazing. Okay. Ka says, I'm going through this right now. My son had all these behaviors never brought to my attention until I filed for an IEE, and the FBA showed all these behaviors, and now he has a BIP, and I want an ABC log. Oh, girl. Have you written to me separately? Because let's have a chat. There's a lot there. There's a lot of jargon there. There was a lot of jargon there. And for those of you who followed that, give yourself a gold star. You're doing well. But yeah, don't let them, if they did not notify you and all these things were going on, don't let them squeeze your child out of their program, because they clearly don't know what they're doing. Can they do that without a manifest meeting each time? No, they have to have, in order to, if it's as a result of a behavior that your child did and they're going to take them out of a program, no. In fact, there's a thing called prior written notice. If they're going to change anything, they have to give you prior written notice. So ask them, where's my prior written notice? You're in violation. But let's get you an advocate. Parker says, we need Bonnie and other advocates in the partners, parents corner. Yes, we absolutely do. But don't forget, Bonnie always recommends that you go to COPAA.org. That's the Council of Parent Attorneys and Advocates. And that's a great place to start if you're looking for an advocate, right? Thanks for watching Autism Live. If you found anything helpful in this video, please give us a like. In fact, make sure that you smash that subscribe button on YouTube and give us a like on Facebook. You can also follow us on Twitter and Instagram for important updates. And please download our free podcast wherever you get your podcasts. See you next time. Until then, give your kiddos a hug from me and one for you too. Bye-bye for now.
To subscribe, click here. And if you'd like to check out some more of our videos, click here.